Roe v. Wade sort of takes the concept of contraception as a protected right of privacy and stretches it. I won't say beyond its logical bounds, but it stretches it fairly far. So I'm going to go ahead and give you the issue in this case before I do the background, because the background is somewhat important. So the issue in this case is whether the right to privacy, as announced in Griswold, covers the decision to have an abortion. And in a 7-2 decision in 1973, just a few years after Griswold, the court says yes, absolutely, yes, it does. So a pregnant single woman in the state of Texas alleged that she had been raped and was prohibited from having an abortion, since state law in Texas made it criminal to attempt an abortion on a woman except to save the woman's life. There are a number of questions surrounding the background of this issue. One that we're going to cover just because, while no matter what side of the ideological spectrum that you reside upon, there is a precedent that comes out of Roe that everyone agrees is a good precedent. And that's this. The nature of pregnancy is, we understand it pretty well. It takes place at a maximum of 9-ish months. Now, the process of getting to the United States Supreme Court is certainly much, much longer than 9 months. And so the woman in this case has long since had her child when this case is considered. So the question should naturally arise, well, doesn't that make this case moot? The legal issue in this case is not resolved, but there is no legal issue in this case, at least concerning the two parties. And so the court puts forth an exception to the mootness doctrine in this case. And that exception is capable of repetition, yet evading review. So something like pregnancy. And so that's how the court reviews this case, as they provide an exception to the mootness doctrine. Now, that mootness doctrine is one of the precedents that comes out of this case. Obviously, it's not the most famous precedent that comes from this case, but it is a very important precedent which has been used to apply to other cases in which the timeline nature of the case would prevent the Supreme Court from ever reviewing the actual legal issue that was taking place. So, the majority opinion in this case is long. It is also somewhat technical, and I will also say, looking back on it many years later, is also in many instances factually incorrect. The decision in this case is well over 70 pages. It goes over a worldwide history of abortion, laws relating to abortion, and a number of things. The Supreme Court knew this was an exceedingly important issue and didn't want to really skirt around it. They wanted to tackle it. So Justice Blackmun writes the decision. Justice Blackmun says that there is a constitutional right to privacy. Let's get that out of the way. It's based within the penumbra of the Bill of Rights, and through the 14th Amendment is applied upon the states. The district court says that this fundamental right was based in the 9th Amendment. Either way, the Supreme Court says that abortion exists within the zone of privacy as a fundamental right. That is, the right which extends to marital issues and sexual privacy also includes contraception, and we also know further that it goes, at least in this case, to a woman's decision whether to terminate her pregnancy. Blackmun says that this right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The court asserts that a fetus is not a person, but in order to do that, they have to develop a framework in which to understand how a fetus isn't a person. Well, why do they have to do that? They have to do this because the 14th Amendment provides protection to any person. And therefore, if the fetus is considered a person, the 14th Amendment would apply to the fetus, and this would become an even more complex issue. So the court insisted it was making not a moral or philosophical argument, but it was merely making a legal one. The Blackmun says that while those trained in respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus on when life begins, the judiciary, at this point in the development of man's knowledge, is not in a position to answer that question either. But they do understand that at least in the 1970s, there did exist a framework which taught us about the viability of a fetus outside of the womb. So the court articulates what is known as the trimester framework. And that is pregnancy being divided into 3-month stages. And the court uses this as a mechanism to really talk about the viability of a fetus and what role the state has in, what interest the state has in protecting the life of a fetus. So in the first trimester, the first 3 months, the state has absolutely no interest in the unborn fetus, and thus the woman can have unfettered access to abortion with no state intervention. Within the second trimester, things change. The state does have an interest in the health of the woman, but not in the fetus, and thus the state can regulate how abortions proceed to protect the health of the mother, but the state cannot stop a woman in the second trimester from obtaining an abortion. But in the third trimester, things change. The state now has an interest in the life of both the fetus and the mother, since the fetus can be considered viable outside of the womb. And thus, within the last trimester, a state can prohibit abortion entirely if it chooses to, although the state still must have an exception and must consider the safety and health of the mother. Now, what I can tell you many, many years later from beyond this is that this trimester framework, this signaling about concerning the viability of the fetus is absolutely not the case currently. Fetal viability, as medical science advances, becomes earlier and earlier and earlier on in the life cycle of growth of the fetus. And this trimester framework is extremely inflexible to recognize the advances of medical science. So this trimester framework received a lot of criticism, not only from conservatives, but also from liberals, for simply being too rigid and inflexible. But it's an important part of the case, one that ultimately does get struck down fairly soon. But it was a lot of time was devoted to this in the majority opinion, so you should actually know about it. Let's take a look at some of the concurrences and dissents. So Justice Stewart concurs in this case. And Justice Stewart, bless him, is the individual on the court who is not going to shy away from saying that substantive due process is clearly involved in this. And he says very simply that substantive due process is alive and well concerning fundamental non-economic rights, and I now accept it as such. Recall in Griswold that Stewart dissents. So Stewart dissents from the case that provided contraception to individuals in marital confines. He concurs in the case that deals with the right for a woman to terminate her pregnancy. So in dissent in Griswold, in the majority in this case. And he basically says that, look, substantive due process is alive and well, and it should be in the issue of privacy, and especially in the area of individual rights. He's changed his mind clearly in the 7 years in this interpass, and that's a notable change. Justice Douglas also dissents. Justice Douglas argues that basically Calder v. Bowles says that within the Constitution, we know that there are certain blessings of liberty guaranteed by the Constitution that are not explicit, and one of those includes the decision of a woman whether or not to bear a child. He simply sees this as a logical extension of Griswold. There are 2 dissents in this case. Remember I said it was a 7-2 case. Justice White dissents. Justice White's dissent, if you changed it from Justice White's name and put Justice Stewart on it and didn't realize that in 7 years Stewart had evolved on his jurisprudence, it would sound exactly like Justice Stewart's dissent in Griswold. He basically says there's no such thing as a fundamental right for the courts to protect, and that substantive due process is not an ideal path by which to invoke these rights, and all of these, the nature of these rights should be left up to the political process through the legislatures. Justice Rehnquist is also in dissent. Justice Rehnquist argues that the notion of fundamental rights and liberty are broader than those rights enumerated in the Bill of Rights. He absolutely recognizes that that's a reality, that there exist fundamental rights, they're broader than the Bill of Rights, yet they are protected by the Constitution. And those rights, like all of the rights within the Constitution, are not absolute, such that a person can be deprived from those rights so long as there actually is due process of the law. His argument is that due process was followed in this case. The state passed a law in a constitutional manner. The state had a rational relationship, that law had a rational relationship to a valid state objective. Thus, there was due process, and therefore, abortion, whether it's a fundamental right or not, can be restricted because due process has been followed in the establishment of the law which regulated the practice. He also makes a good point. And while in the last case I mocked Justice Rehnquist as old man yelling at cloud, in this case he does make what I think is a very succinct argument about the notion of substantive due process. He says that the majority opinion quotes Justice Holmes' dissent in Lochner. And that seems odd because Justice Holmes' dissent in Lochner was warning about reading things into the Constitution via substantive due process and saying things are fundamental rights. And so Rehnquist says that, quote, this case is more closely attuned to the majority opinion than Lochner's dissent, or than Holmes's dissent in Lochner. In essence, you're doing a sort of disservice by citing Holmes's dissent in a case which used substantive due process in such a way as to read a right into the Constitution, and Holmes was very much against that process. You can't really cite him, in all honesty, while similarly reading a right into the Constitution through substantive due process. That seems at the most disingenuous.